Hello, my name is Yoni Levoritz and I'm from the Levoritz Law Firm. And I'd like to talk to you today about the Jewish marriage contract known as a Ketuba. A Ketuba, typically speaking, has no bearing on the matrimonial case whatsoever. Yes, there are promises and there are sums stated and there are clauses in there regarding support. However, it's not signed in the form in which a deed has to be signed and executed. Therefore, it is not binding. However, there are some ketubas, Jewish marriage contracts, that are signed in the way that a marriage agreement is supposed to be signed, which is in the same form as a deed. And I know that sounds sort of repetitive, but that is the law. The law is that a matrimonial agreement, a postnup, a prenup, any agreement regarding the marriage, regarding division of property or anything else basically, has to be signed in the form of a deed. So there's a famous case known as Avitur via Avitur. It's a court of appeals case, which is the highest court in New York. And that court upheld the marriage contract as being valid and binding because it was signed and done like a deed. It was written more like a prenuptial agreement than a ketuba is typically written. And therefore, it was good and binding. So it resolved many of the issues to the marriage that did not have to be litigated. It's important to keep in mind that if you do go that route, the avitur route of having an agreement which is good and binding, that you have it negotiated by counsel. You don't simply walk into the marriage and sign it like you do a Jewish marriage contract, a ketuba. You go ahead and you sign it knowing that is a legally binding document. Do not just sign something because it seems good at the time to do it. It is important to keep in mind that you have to do it in a certain way and maintain the formalities. I thank you very much for spending time with me today. Remember, this video is for educational purposes only and not to form an attorney-client relationship. Best of luck. Thank you.